All right, good evening everyone and welcome to our event on expanding your business globally. It's really great to have you all here this evening. We are going to be talking about everything you need to know from a legal perspective for your expansion. We are going to record this evening, and we will be sending out the slides, so you will not have to take a million notes if you don't want to. I'd like to start by introducing our expert panel this evening. First up, we have Helen. Helen is our tax expert. She has been a corporate tax lawyer for 10 years now and has expertise in tax-effective structures for corporations, startups, SMEs and individuals with high net wealth. And when she is not busy helping our clients, she is in search of the best dumpling. How's that going? Have you found the best place on the Central Coast yet?
I have, I think. I'm still on the search. I found a place in Saratoga. It's called Tan's Dumplings. It's a bit far from me, but I'm still going to venture out. And then today, actually, I had lunch around the corner at this little hole in the wall, and it sells momos. Amazing. $10 as well. No. So for 10.
You heard it here. Thank you so much, Helen. All right, Stephen on the end there is our senior lawyer in the corporate and commercial contracts team, and he provides commercial and regulatory advice. And he previously worked as an in-house counsel in a multinational consumer goods business and lived in China. So can you tell us, Stephen, what was it like? What was your best experience living there?
It was definitely an interesting experience, so not one that I sort of planned that I'd be taking. I started as a graduate and did a year in China for this business. I was in Shenzhen, sort of southern China, right by Hong Kong. It was a city that was built from scratch 40 years ago. So a lot of thought obviously into infrastructure and design and technology, which was just really incredible to live in, and sort of be the hub of Alibaba, Huawei, all those major companies were as well. So just a really sort of tech-focused city, and obviously proximate to a lot of other places in Asia too, which as a sort of 20-something-year-old at the time was very useful and a lot of fun. So yeah.
Excellent. Thank you for sharing. And finally, our IP trademarks guru, Chris, who, as I said, is all things trademarks. And when he's not helping clients with protecting their brand, he's joining me in a yoga class or chilling over a coffee and a comic. Hey, are you into Japanese manga by any chance?
I love it.
Which series do you like the most?
I think my favorite series at the moment is Frieren. I'm not going to bore anyone with the details here. We won't go into it, but highly recommend it.
Thank you so much. All right, so our panelists are going to be talking tonight about legal entities, best tax structures and tax tips for you, protecting your brand overseas. We're going to get into tips and tricks to help you protect your business for all things for expansion. We will open the floor to questions at the end, and then at the once we wrap up, you're welcome to stay around and have a drink and socialise and network until 7:30 when we wrap up for the evening. All right, without further ado, I shall leave it on that. So actually, you know what? I think I'll just do a quick audience poll. Could you tell me, please, if you have already expanded your business overseas? Could you just put your hands up? Yeah, a few people. Yeah. And what if you are planning to expand overseas but haven't done so yet? Hands, a couple of hands. Yep. Okay. All right. And what about which countries you've expanded into? US? Yeah. New Zealand? Yeah. UK? Europe? Yep. Okay. Cool. Thank you very much. That's very helpful. All right. So we're going to start off with Helen with legal entities. And I wanted to ask you firstly, why is it so important to have the right legal entity when you're expanding overseas? What difference does it make?
Well, why is it important? Well, there's many reasons, but from my perspective, it's really important to understand what you're actually trying to do in the first place, understand what your long-term plans are, because each person is very different on what type of entity they should be using. It depends on which country you're going into, what your current structure looks like right now. What are you wanting to do? Are we bringing on investors? Is it just you and your wife, or is it just you yourself? Understanding what you're actually doing really dictates what type of structure you should be using, what's more appropriate from a tax perspective, legal perspective, but also a contractual perspective. And as Chris is going to go through, the type of entity is really important when thinking about how to protect your IP, trademarks. And then also understanding, so from a tax perspective, I guess not getting the right entity means you might miss out on certain concessions or be taxed differently to if you were set up, for example, a trust or a company. I find that people don't understand the difference between the two sometimes, so it's really getting that right at the beginning. Some jurisdictions, as some of you that are already expanded to Europe, a trust structure is not understood, they don't use it, so it's a look-through approach, whereas some countries will have a different type of corporate structure. So for example, in the US, as some of you already know, having an LLC is a type of partnership and is not a company. So then the question is, do you set up a C Corp? So yeah, there's various reasons as to why it's really important to get that structure or understand the type of entity you're actually using.
All right, so thank you for that. What are the most common legal entities that people are using when they're expanding overseas? And can you tell us a bit about the pros and cons of them?
Yeah, so as I mentioned earlier, there's the most common one, and I think some of you may already know this because it sounds like some of you have already expanded, is having a corporate structure. The reason why corporate structure is most commonly used is because of the flexibility when you're bringing on investors, the ability to actually grow. So when you have a corporate structure, ordinarily what we see would be a holding company, whether it's in Australia or in another jurisdiction. We have seen people setting up in the US most recently. And the main reason we've seen from our perspective, because of the type of clients we have, is that investors are in the US. So a lot of accelerators, a lot of high wealth, investors are in the US wanting to invest into Australian brands or Australian products or software, and understanding, obviously, like I mentioned, having a C Corp or an LLC, it gives the flexibility to then bring on investors, having shares that we can issue, as opposed to a trust structure, which is very inflexible, very difficult to understand, not accepted by a lot of jurisdictions. So yes, the corporate structure is one of the most commonly used. There are also tax benefits for having a corporate structure. One of them is that, for example, if you were to set up an Australian head company and you had multiple subsidiaries in other jurisdictions, the flow through of funds coming back into Australia via a dividend would be, most cases, tax-free if you meet certain conditions. So understanding, the flow through of money, where's money sitting, how's it coming back, really dictates, what type of structure is appropriate.
Thank you for that. So just while we're on structures, Chris, why is a structure important for protecting your IP?
That's a really good question. So ownership is very important when it comes to IP, but trademarks specifically. So if you do have a particular corporate structure where the IP is being held in one particular entity, but is being licensed to an OPCO, for example, then you need to make sure that you have that sort of agreement in place that authorizes that relationship, essentially. Because if there isn't that paper trail, then potentially the registration for that trademark can eventually become vulnerable to removal, which is not ideal, obviously.
Thank you. All right, let's turn our attention to tax and back to Helen again. What are the key types of tax that you need to be aware of when you're expanding your business overseas?
So the key types of tax that a lot of people Sorry, a lot of tech issues in a tech firm, so. So some of the tax that, interesting, you raised the IP. A lot of people don't realise that if we have IP in one country, I'm just going to talk about that because everyone has IP, and so understanding where you're holding your IP, how to protect it, obviously really important, having the right entity. It really then it flows down to, if you have the IP in one entity, who's using it, which country is using it, where is the money flow? Are we paying for the IP, are we paying for the use of it? And then if we are, how is that then going to be taxed? Who's taxing it? What type of tax do we need to be aware of? The most common one is, when we're talking about IP, is withholding tax. So when money's leaving a country and going into another country, you are likely to be subject to withholding tax in the jurisdiction it's leaving, because that country doesn't want to miss out on the taxes that, is with money leaving the jurisdiction. And then the other country needs to be aware of the income tax of the license fee coming in. And then the flow on from that is understanding whether transfer pricing is going to be an issue. So transfer pricing is something that commonly arises when we're transacting between two entities and between two jurisdictions. The reason why that's important is if what it's preventing is assets or money being shifted out to another jurisdiction without arm's length payments being made to it. If that's happening, then both or one country is not going to be very happy that, there's assets being moved out, nothing's coming back into the jurisdiction. So really important when you're thinking about expanding is transfer pricing. Is money leaving the country, is money coming back in? People do actually forget about it and don't realise there's a risk, and they start paying things all over the place, moving money between different jurisdictions. And then without realising they've actually breached a transfer pricing issue with both jurisdictions. The other tax is sales tax. So actually I was speaking to someone earlier in this room, is when we have consumers in other jurisdictions, and this includes when you have software that's being used by consumers in a different jurisdiction, you may actually have to pay sales tax, and that is GST equivalent in the other jurisdiction, because you have consumers using a product that's currently in another jurisdiction. And some countries have certain thresholds, or some jurisdictions may start from 0. So it's really important understanding sales tax. You may inadvertently trigger it without realising.
Thank you, Helen. I just wanted to, you mentioned some of the problems. Are there any other major problems that people should be aware of from a tax perspective when they're expanding overseas?
Yeah, I guess the key one is actually residency. When you set up overseas, you think, oh yes, I want to save a lot of tax, so I'm just going to set up in a jurisdiction that has no tax. We get a lot of clients that are wanting to set up a company for that reason, which is, I can completely understand. But in Australia, even if you set up a foreign company, that foreign company, if it's controlled and managed here in Australia, it will be taxed under the Australian tax regime. So unfortunately, it's not as easy to not pay any tax if you are the controlling person of that particular entity. It's really important that you're getting advice right from the get-go, because people don't realise, and you may then inadvertently be, taxed later on. We actually have a client who set up in Singapore 3 years ago. They've been deriving millions of dollars in Singapore. We had a conversation with them, realised that the control and management actually is in Australia. It was obviously not great news to tell them that potentially the ATO may start investigating, particularly because we were about to do an entire restructure. We're about to transfer shares, and as some of you may know, the ATO and ASIC now are working together. So anything you do on ASIC, changes of shareholding or directorship, is likely to trigger off something with the ATO. And so they may start investigating as to why have you done that, and then looking into the affairs of that particular entity overseas. So there's that risk. You just need to be really careful and understanding the control and management point. There are ways to mitigate this, but it depends on every person's individual circumstances. Just one other point on the residency. Sorry, I'm talking a lot. But the residency point, people don't realise, is also personally. So yes, you set up in the other jurisdiction, and you think, you know what, I'm going to actually move overseas because I don't want the control of management here in Australia. You've actually then triggered off another taxing event on yourself personally. So then if you cease your residency here in Australia, you may have to pay tax on your shares that you hold in your holding company. And we've had that happen quite a few times with clients who don't realise they've actually ceased residency and they've got a lot of tax now to pay on their shares on the holding company. And the reason why they've expanded is because the company is now very successful, and this includes a trust entity as well. So trust entity, individual, ceasing residency triggers a taxing event. Really important.
I think the other thing as well, when choosing, if you are thinking about expansion and you're sort of looking at that kind of possibility of maybe a low tax jurisdiction or somewhere else, is whether it's an easy place to do business. There are a lot of low tax jurisdictions that have very high bureaucracy requirements. So I know a few jurisdictions where if you want an official document for sort of international use, it has to go to a notary public. It then has to go to the High Court of another jurisdiction like the UK, and then it would have to go to the embassy of maybe the jurisdiction you actually want to use that document in. I had a client where every time they wanted a document done, it was $10,000 per page, US. So there's that sort of consideration as well, that just because you might be getting a 3% tax rate and you might sort out all the foreign residency and control requirements, it's also good doing some due diligence around what does the actual red tape look like in that jurisdiction, and is it actually an easy place to do business? Because sometimes your home jurisdiction can be easier for that reason. But yeah, that's kind of part of that balancing exercise.
Excellent. Oh, okay.
Point of other things you should consider is the types of concessions that might be available in that jurisdiction. So thinking about, are there concessions here in Australia that may be more beneficial rather than setting up overseas? And do you need to actually set up overseas? Is it relevant? What are you trying to do? Going back to that same point.
Great. There's clearly lots to say on that, so it's good that you shared all your knowledge. All right, let's talk about brand for a little bit. Look, your brand is probably one of your most important assets. So when you're expanding overseas, Chris, what are the first steps you need to take to protect your brand, and when should you start putting that in train?
So when you're talking about protecting your brand and the relevant IP there, obviously various different types of IP make up a brand, but the most important one is a trademark. Those are things like your name, your slogan, your logo, etc. There are a couple different ways to, well, there are two ways to expand your trademark protection overseas. One is to file a Madrid protocol application, or you can file directly in that particular country via an associate with that particular trademark office. The reason why you would probably want to do a Madrid protocol application is because you can do it yourself. You don't need to involve an associate overseas to file it for you. And just sort of jumping back, the reason why you have to do that is because trademarks operate on a country-by-country basis. So a registration in Australia doesn't entitle you to one in the US, for example, or you have to go through the same process, essentially. So that's the main one, is, well, the first point, which is how are you going to file. The second point is how you're going to maintain these registrations. So Australia is pretty relaxed when it comes to maintaining trademark registrations. Generally, if you've got the registration, you don't have to prove that you're using it unless someone challenges registration. That's not the case in many other countries. The US, for example, has quite strict maintenance requirements and ongoing deadlines that you have to meet and demonstrate evidence of use in order to maintain those registrations. So that's another thing that you need to keep in mind if you are going to expand internationally. And then the last one, which I think goes to Lainey's last point of that question, is when you're going to file. Theoretically, you can file whenever you want if you have an intention to expand internationally. But if you file within 6 months of filing an Australian application, you can actually do something called claim priority and backdate the date of filing your international application so that it matches your Australian filing date. So it's a nice way to kind of get in there and maybe get ahead of any potential ne'er-do-wells that may try to cut you off at the legs in another country, for example.
Thank you. What would you do if you are expanding overseas and you discover that another company or has the same name as you in that target country that you're looking to expand into, and they already have that trademark registered?
Yeah, that's a pretty difficult situation. It would really depend on what this other party is doing, if they're operating in the same industry or offering the same goods and services as you. If they are, that's a bit of an issue, and you might have to consider potentially adopting a different brand in that country, a la Hungry Jack's and Burger King. The other thing you might want to consider as well is that if they aren't offering in your area, or they might be offering a specific type of software, for example, that is unlikely to be confused in the marketplace, you might consider negotiating coexistence with them. I would really only recommend doing that if you have some form of leverage over them. For example, if you've got a registration in Australia that's blocking their application and vice versa. That way you can kind of negotiate a global coexistence agreement, which is fairly common, and that's a way that you could potentially circumvent that potential issue.
Thank you very much. All right, lots to think about. Let's move on to contracts. So when you're setting up in a new country, there is so much to think about, right? There's different cultures, there's different payment systems, currencies, languages, legal systems. So protecting your business becomes really important, especially with your contracts. What are the key types of contracts that are required? And perhaps you can also talk a bit about what may be some of the key terms that people should be thinking about.
Yeah, absolutely. So, I mean, the primary contract that most businesses will have is the sort of the revenue generating ones. So usually with your customers, and what they, I guess, kind of depends on an industry requirement, what you're dealing with, whether you're dealing with online or sort of offline, the more traditional. In terms of those contracts, it really comes down to your type of customer. Are you mostly sort of a B2C, dealing with consumers, or are you dealing more B2B? Because that can have some very differing impacts in terms of legislation. We use Australia as an example, you know, certain thresholds of contracts with in a B2B setting, you know, have less obligations in terms of the consumer law. In New Zealand, for example, you can contract out of the consumer law if it's a B2B transaction, which is something a lot of people forget, which is quite a nice little hack from New Zealand. Other jurisdictions, though, might not have any protections for B2B, and it is very much just a freedom of contract basis. So understanding that framework is really important from the get-go. It's also important too because it also can impact things like what you're doing in terms of maybe privacy and data, and how that might work when you're dealing with maybe other businesses, or what consents you need from your customers in order to share their information with maybe your service providers. So if you outsource anything, or if you're sort of, say you're in software and you have sort of processes in the back end that help with that data, and you need that consent to disclose, that's where sort of things like your customer terms become really important. And it also becomes important too in terms of just establishing your role and what you're providing as a service. So if we take a marketplace, for example, you want to be really clear in those terms that you are just the invisible hand, you're the facilitator, you're not actually supplying the goods or services that the vendors on your platform are putting on there. And again, that can have very important impacts from, say, like a consumer law perspective, but as I'm sure Helen could speak to, you know, there are multiple kind of run-on impacts for tax and other liabilities if your terms aren't drafted correctly, especially, you know, we see that all the time with just Australian contracts and how various revenue and tax officers will interpret something based on what the terms say and what's happening in practice, and that goes for other jurisdictions as well. So on a customer front, you know, in addition to all the standard stuff around your liability, IP ownership, it's just about understanding the framework and what's regulated and what's not. I guess in terms of other things, if you've got suppliers, again, what industry you're in will dictate. Goods is obviously a big one, especially if you're dealing with cross-border transactions. So if you've got factories, for example, and you've got factories overseas, having contracts is good for expectation management. Sometimes there's a practical enforcement issue. So if you've got a contract with a counterparty in China, the practicalities of you as a foreign business being able to actually bring a lawsuit is quite difficult. There are more hurdles for foreign companies, just like most jurisdictions will have more hurdles for foreign companies. So it's about trying to work out, how can we make our contracts clear from an expectation management perspective. Obviously, we want them to be watertight if we, do sue and can sue, but also from when we're just thinking about investment and exit options. So if I've been asked, or if any of us get asked to do a due diligence on your business by an investor, not that, it might be us, but any lawyer, we're going to go through and we're going to look at what you've got, kind of look under the hood and say, well, what have you got in place, and does that give us confidence when we write a DD report that your business has everything it needs? So, a lot of businesses will go on the basis of, I don't need a contract because I've never been sued, or I don't really have any issues in my industry. It's actually about sometimes just demonstrating to the people that you want to have invest in you, or who might buy you out, that you are a good business to invest in and that you've done everything by the book. So I'd say that's really important as well.
Thank you. You might want to keep that on. So I have another question for you. What can go wrong? Like, can you give me, if you don't do it right, what are some examples of like hairy examples maybe?
Yeah, some hairy examples. So a good Australian example is businesses that provide financial services that don't have a contract with a license holder. They're providing an unlicensed financial service and could go to jail. So that's like a very bad case scenario of, and if we apply that into an international context, there'll be similar regimes where license holders, you require an authorization or a license, and those sort of contractual arrangements being in place is important to actually comply. The EU is a really good example of where if you're in businesses dealing with cosmetics, chemicals, most consumer products, to be honest, and now I think there's a new digital platforms legislation in the EU as well. You're required to have a local representative, so you need a contract with that local representative, and sort of failure to comply with that can expose you. In terms of, got another part of the question maybe? Oh, what can go wrong? Yes, yeah. The other one that's really common is IP, or lack of IP, because you don't have a contract. So some jurisdictions, there's a default presumption that if you've paid for something, you'll own the IP that comes out of it. In some jurisdictions, it's not the case. And basically, if you engage a contractor to develop something for you, whether it be a website, content, anything like that, the default presumption is that the contractor owns it, even if you paid them for it. And so you actually need a contract to reverse that presumption so that you own the IP. And under a contract of services, that can have, sort of tax benefits because you're paying for the service, you get the IP. If you have to do a patch-up job and say, okay, we'll assign the IP later on, then that's potentially a tax event with maybe capital gains implications if there's a jurisdiction that has that, or some other tax implications. So, and also the contractor may just say, no thanks, I'm not going to sign that, and then what do? You might have to start from scratch. So I've seen that a lot, especially in software, with software developers, where it's sort of I found them online, I found them on eTasker, we're just like building this and just kind of hobbling it together, and there's actually not adequate protections in place.
Great, thank you very much. So we've had a lot of information tonight. What about we just do a quick key takeaways for each of you? What are the most important lessons that people should be taking away for each area? Do you want to start, Helen?
I think the key one for me is actually planning ahead. So I'm thinking about what is your long-term, even short-term plan, and why are you even going overseas? Do you need to incorporate overseas? If you don't, then maybe we just stay in Australia and then look at other types of arrangements like distributions or branch. So planning. And I think that kind of flows on to, once you know what you want, getting the right advice. So that doesn't mean, going on Google or asking ChatGPT. I don't know if you can even do that, but what should I do? How do I move overseas? That information isn't helpful, and as you know, based on everything we've said tonight, it's complicated. Moving overseas is not simple. There are a lot of risk from IP, tax, contract, data protection, and then understanding what those risks look like, so getting the right advice. And I guess thirdly, from my perspective, is what your friend has done doesn't mean you should also do the same thing. So just because they've set up a particular structure, just because their lawyer said they should do this, it then applies to you. every circumstance is different. One detail may change, the advice has been given to you. That's my key takeaways.
Chris, do you want to go next with IP?
Yeah, sure. I'd say my 3 key takeaways are consider filing by the Madrid Protocol. It's a great way to file in multiple countries in one application, so it's a lot easier to manage. Another point is make sure that you've got an idea of, first of all, your portfolio and how you're going to maintain and monitor your portfolio. And then finally, another major key point is can you claim priority if you are going to file overseas?
Thank you. And last but not least, Stephen.
The classic staple, so always have a contract. Sort of as a contract lawyer, I guess that's my job to say that. A non-contract one would be, just coming back to that point about, if you are making the decision to set up overseas, and you're trying to weigh up, can I do this as, from Australia? Do I actually need to set up an entity there? So obviously considering what the red tape will look like, that example I used earlier about the $10,000 per page fee that this client was paying, but also what does setting up an entity actually trigger and mean for you? So, for the UK or Europe, setting up an entity or a business presence, even just hiring people might suddenly trigger, GDPR data protection requirements and other requirements. The EU's got requirements coming out their ears. So things like, and tax, obviously, always tax. And takeaway 3 is taxes everywhere, I guess, is probably the big one. So yeah, if you want to speak about tax for hours, Helen's the person to do that with. But yeah, that's really my key takeaways.
Excellent, thank you. So we're going to open the floor in just a moment to questions, but before we do, I'm just going to introduce my colleague, Pat Adams. He's a legal coordinator in our growth team. And he's just going to spend a minute telling you about membership.
Yep. Thanks, guys. It literally will be 1 quick minute before I get to you guys and ask questions to the panelists here. As many of you probably do know, LegalVision works through membership. As you can see on the board, you get access to a whole lot of services. First of all, being our
hold it closer to you.
One of them being our wonderful lawyers. We have over 100 experienced lawyers that you get access to, along with unlimited document drafting and reviews, the consultations that come alongside with those. We look after your employment and HR support as well, and domestic trademarks. Our turnaround times are fantastic. We usually try to get things done within 5 days, and we can work on tighter timelines if required. As a thank you for being a part of the seminar today, you all get access to a free consultation with myself or someone in my team. We'll be giving you a call in the coming days, first of all, to get feedback on today's seminar, also some ideas on future seminars that we'll be having, but also to book you in with us to have a discussion about the wider business and the growth plans you have to see how we can best support you moving forward. So we've got the QR on the screen now. If that sounds fantastic and want to book in a meeting straight away, feel free. Otherwise, yeah, we'll give you a call and then get that feedback as well.
Excellent, thank you. Alrighty, so now we're going to open the floor to questions. Hands up if you have a question.
Thank you. Talking about ownership of IP, one of the common things I see is the business owner registers all the IP in their individual name. We're talking here about the correct residency of the entity owning the IP and royalties and withholding taxes. What's your suggestion to somebody that comes and says, I've registered my IP in all these countries as an individual?
What are you planning to do? No, I mean, look, if you've registered an individual name, my first question is, what is your residency? So if you are an Australian tax resident, then the next question is what are you planning to do? So if you are looking to set up a company and start expanding, so you've got investors that are interested in investing in you, you've got this product in your name, it's registered in your name, do we need to transfer that into a corporate entity, for example? That's going to trigger off certain, tax for you personally. We then look at, is there any rollovers that may be applicable for you to defer any tax, particularly if you're maintaining the same ownership. So those are the things that I would consider. In regards to transfer pricing and also withholding tax, So there's an interesting one, and I was actually going to raise it when you talked about IP, but if you've got, IP registered all over the world, and you're using that same IP in that jurisdiction, you may not have to consider transfer pricing, because you're not moving the use or licensing the use of the IP from one jurisdiction to another. You're using IP that's already in that jurisdiction. So then you're then dealing with the laws in that jurisdiction as to the licensing arrangement and whatever relevant taxes are in that jurisdiction. Then that flows on to, there's probably no withholding tax because there's no payments being made between, two different jurisdictions. Does that answer your question? Okay.
I was just going to add to that as well. Obviously, if it's held in the founder's name too, I guess if something happened to that founder and they died, then obviously, sort of rules of inheritance and all that would control. So, so it's sort of a case of it's high risk. So it seems like I think the logical situation would be to actually transfer it. Part of that transferring as well, there'll be a lot of cost. And that's why, I guess, coming back to that always that classic point, get advice first and set up your structure correctly from the get-go, is that if you think about, imagine you've got, 20 trademarks around the world and you want to later assign them. So obviously there's all the tax, tax event issues in terms of setting the value for the IP, the tax on that value, but also just the administrative cost of actually transferring and updating the registers. So if you take the US, for example, only a licensed US attorney can make changes to the USPTO's or the trademark office's register. The US isn't cheap for legal fees, so that is that's a cost in and of itself. Paying each lawyer in every jurisdiction to file the update for you and process that, and that can be, I've done that before for a client, and that can be tens of thousands of dollars just alone. So yeah.
I've got a question in IP as well. Let's say if you have to expand to the overseas, would you rather find a consultant in overseas first or come to somebody in Australia? Because the reason I'm asking the costs I'm talking about, because obviously the lawyers in Australia wouldn't do any applications in overseas, right? So from CEO perspective, if you want to expand it, you're going to go and find a consultant in overseas, what they do now. They do things first, right? So you find a consultant first in overseas and then come back to Australia. How they engaging it? That's the further question.
Is that just in the context of you've got a new business idea or you're wanting to start filing protection for IP, right, or more about how to set up your business?
Probably early stage, yeah.
I can start and then, yeah. No, that's right. I mean, if you're thinking from like a setup and new business perspective. So if we took, for example, you've got a new business with a new invention and a new brand. So you can likely, there's these international filing pathways, and one of them that Chris has mentioned is the Madrid Protocol for trademarks. And then you've got the Patent Cooperation Treaty for patents. And then the other one, I think, is it Madrid for designs as well? I forgot what the designs one is called. But basically, say you've got this invention, you want to protect how it works. You might engage an Australian patent attorney to start that process for you. And they will draft your patent and they'll file it in Australia. They'll file an international application with the World Intellectual Property Office, which is kind of like a private sort of non-government organisation. And then from there, you can then kind of designate it down into every country. And the Madrid Protocol works in the same way. And whatever the design one is called also works in the same way. Where you might, and where you sometimes have to be careful, particularly with patents, and in the US, designs are also patents, so designs protect how something looks, is where you've actually developed this invention. So something that a lot of people don't know is some jurisdictions have kind of export filing requirements, or kind of, I guess they're kind of like security, making sure you haven't got something inventive that could be of military or state secret use. So the US is one, China's another one. There's a few of them where if your development has actually happened in that jurisdiction, you have to file there first. And if you don't file there first, it can impact the validity of that patent on the line. So you developed in the US, but you file it in Australia first, and then later on it comes out that you didn't actually, your development was here, you didn't go through the US patent office first. That can impact the enforceability or even just the viability of that patent itself. So that's sometimes where you might have to consider, where is it based, but also sometimes where the inventor is based will have an impact on where you have to file first. So it's kind of a multi-layered question, but yeah, it's start with us, yeah, and then we'll tell you. Yeah, a lawyer here will soon tell you if it needs to go elsewhere. Yeah, great, thank you, Jackie.
Just because your question was also, do you speak to an Australian lawyer first or to the other jurisdiction first? It is a difficult one because obviously you're dealing with two different jurisdictions, and I completely understand. We actually get a lot of clients that come to us and say, I don't know what to do. Like, who do I speak to first? And I also don't know who I speak to in the other jurisdiction. My view is that you should start with your residency. So where is your tax residency? Have your conversation with the lawyer in that jurisdiction. So if in Australia, speak to your Australian lawyer. I would suggest a tax lawyer because they would plan and structure. So speak to me because you want to plan, what are you doing? Where are you expanding to? How do we structure this? So that would be, if I was speaking to you, that would be the questions where I would ask you and we'll go through is, what are you wanting to do, which jurisdiction, and how do we plan this? Because there's a lot of implications, and then thinking through, do we even need to have a conversation with the lawyer in the other jurisdiction? If you do, we have multiple partners we work with in many jurisdictions. So I work with a lot of US lawyers and we partner together. So in a recent case with a client, they were in the exact same situation, and we ended up having multiple conversations in Australia and then having multiple conversations with the US lawyers to understand where, at what point do we need to incorporate a US entity. And now they have a plan and a structure, and they're doing it within a certain time frame. So start with your tax residency. That's my view.
So I worry about cyber and a breach in one country. Are there things we need to be thinking about to protect the group as a whole if you've got a breach in one entity?
That depends. I guess it depends on which entity first collected that information sometimes. So if, for example, I'll use Australia as an example because that's a bit easier. So if you are the entity in Australia, you've collected data and you've maybe disclosed it to a related entity, you generally have the obligation to, or you should have the obligation to contract or have internal controls to make sure that you've got adequate data protections in place. The GDPR as well as another example. If you collect personal information and that kind of makes you the controller, and then you might be outsourcing or using your related companies to process or to kind of provide back-end support, you'll need to have adequate protections in place from that perspective. From a group level, it's generally speaking, like if we've got a foreign entity that's sort of got nothing to do with it and it's just localized, then it should really be within the laws of that jurisdiction. I guess where things might get messy is if you've got foreign entities doing business here when they shouldn't be, or you've kind of mixed up your group structure. I see a lot of clients who come to us with their terms and conditions and they'll have all their entities listed and it's actually clear who they're contracting with, or they'll use their foreign company to contract in Australia and not their Australian company for whatever reason. And then that company can be drawn in and that can have implications as well. So yeah, and then there may be, I guess, flow-on reporting requirements in the other jurisdictions that have tighter privacy controls. But yeah, it's sort of about having those adequate intercompany relationships, which ticks off a lot of boxes in terms of taxes, transfer pricing, things like that, and privacy is one of them around sharing.
I've got a question about from a SaaS perspective, so software as a service. If you're selling overseas, so one thing I'm a little unclear on is, do you actually need to create any entities overseas if you're just selling SaaS overseas, for instance? So, and what are the pros and cons in terms of, okay, if you are a SaaS business, are there any benefits in terms of expanding overseas, or can you just, essentially run the entire business from Australia and, charge the right prices and goodness knows whatever else you need to do?
So yeah, we actually get that question quite a lot, and people think, oh, I should set up a company in that jurisdiction because I'm now looking at expanding there. And this goes back to that point I was raising before, is do you even need to set up overseas, which is a really good question. And in that case, you probably don't. But it depends on, are you thinking about employing anyone there? Most likely not. I mean, if you're not, then no, you probably don't need to set up an entity. But if you're going to engage developers over there, you're thinking about potentially developing further IP on that side with certain consultants, maybe doing some sales over there and marketing, then what may actually happen is you may trigger off the permanent establishment rules, which is essentially you've created a branch in that jurisdiction. So when you start creating a presence in the other jurisdiction, if you may be deemed a branch, and then there are certain taxes that you then have to pay by your Australian entity. And it just generally is higher than the local taxes. So then you may want to actually set up a subsidiary there and you pay less tax, but then you obviously have other taxes you need to consider, which is the withholding taxes, transfer pricing, how do you fund it, who's going to own it. So then, is it now too complicated? Do we just stay as a branch? Do we even need a person over there? Maybe we actually just set up a employer record arrangement. Maybe it's a matter of, having certain types of contracts as opposed to setting up a branch. Did you have anything to expand on that?
I think the only final point is, even if you're located outside, there's sometimes these loose notions and legislation around if you're doing business in a particular jurisdiction. So if you are, and I know some of the privacy, states in the US have privacy laws, they'll talk about this notion of if you're doing business in the state and you meet these certain thresholds, maybe around revenue, around the sort of volume of data that you're processing about residents in that state, then you may be required to comply with their local laws. Just as if you're sort of targeting, maybe Australia and you're a foreign business, those customers may have, rights against you under Australian laws. Again, practical question of how does that work, but it can still, it's not sort of an immune position, is probably a key takeaway there.
Oh, okay, we'll do one last question. Oh, 2 last questions? All right, we'll make them.
Yeah, there's a remarkable ignorance in terms of AI and patents here in Australia. Oh, it's software. No, don't bother. You won't get a patent. And I was forced overseas to the US to discover that it was highly patentable. Right? How the hell do you find a lawyer here who understands AI and neural networks and so forth?
Yeah, that's an interesting one, and to the point, like, some, or a good chunk of jurisdictions, software isn't patentable, or it's only patentable in limited circumstances. Some jurisdictions have, like the US, have the ability to do that. It is a difficult question because each jurisdiction has its nuances, and what do you do apart from, do you go and talk to a lawyer in every single country and try and work out, where to start? In terms of your experience and, being told, sort of it's not patentable, but it might be patentable here, I find the usual starting point is what's your long-term strategy if you're trying to work out where you might need to do that look into. So, okay, I think I'm going to start, these are going to be my top 5 markets. I'm going to go find out, is what protections are available to me here, or what sort of things do I need to be aware of? Because there are various, I think Germany has, or we used to have a utility patent, or in Australia, Germany has one. Lots of these jurisdictions have these quasi patents and things like that we might not be aware of. Even just little quirks like in the US, if you want to maximize your damages for copyright infringement, you actually need to register your copyright with the US Copyright Office through their, sort of 1980s internet portal. And so some of that stuff just comes with, sometimes you'll just come across a lawyer who's had that experience. In-house lawyers who, like me, tend to have that experience because we've kind of seen things in terms of dealing with those jurisdictions. So if you find a lawyer that has that experience, that's really useful because we tend to know, we've kind of been in those situations or firsthand. So it's sometimes about finding that, but a lot of the times it's about where do I want to go, and I kind of need to do my due diligence in each jurisdiction. well, I think Jackie would say here. I like to think here as well. We're quite, like we're, in terms of a firm, we're embracing sort of AI and technologies. We have a lot of clients in that space. Generative AI being sort of the big, well, has been the big one. So it's really about finding, I guess, if you're talking about, finding lawyers with that experience, it's, I guess, finding out, what the client base is and who they're dealing with. Go into a law firm that only deals with maybe, industry, mining, things like that may not be the best starting point. Finding law firms that have that kind of, that maybe wider client base or that new and emerging technologies wild base is probably going to be the best starting point. Or I guess, I mean, if there's industry events, there'll usually be lawyers in that space speaking to those sort of things as well. It's sort of a, unfortunately, there's not a nice directory of sort of ranking every lawyer based on what they know. It would be nice. It'd be probably terrifying. I want to be up there for tax. But that's, I think, in my experience, that's probably the easiest way, is to kind of look at the firm, look at its clients, and look at what firms are at what sort of events.
One last question for this evening, thank you.
Yes, hello, super quick one off the back of the previous question. So if you have a subsidiary or a branch set up overseas, does that not then interfere with then needing to have working rights for that country? How are they separate?
So are you talking about employing someone? Yeah, I see. Yes. Okay, so the question was whether if you're going to have a branch or a subsidiary, whether if you're going to employ someone, for example, the founder is moving over to the other jurisdiction, how does the visa rights work? Is that the question? And whether you need a visa or not. So I'm not an immigration lawyer, and we do have an immigration team, so definitely, call up a complimentary consultation and we can help you there. But in regards to the structure, so a branch is, you don't have a subsidiary in that country. So then the question is, who's the employing entity for that particular visa? You have to look at the requirements of what's in that jurisdiction as to get that visa. I know now there are a lot of nomad visas, so you don't actually need to have an entity in that jurisdiction to be able to show that you're employed in that country in order to actually get the visa. I don't know the various requirements, but my understanding of them is that you can have an entity in Australia that's employing you, and then you're going to be in the other jurisdiction for a certain period of time. And for that particular visa, the nomad visa, you're employed by a foreign employer and not actually an employer in that jurisdiction, the local jurisdiction. So it really depends on, firstly, what type of visa you're going for, and then that shouldn't be the reason, I haven't found in my experience, to be the dictating factor to what type of structure you should have. When we're dealing with employees, because of nowadays you have employer records, Deal is a really good one, that's a platform type one. Those types of arrangements kind of overcome the need to deal with visas or that dictating the structure. Does that help answer your question?
I think it just, in terms of whether you actually need a visa, so it'll just depend on the residency requirements for that company. So some jurisdictions don't have residency requirements, so you can be a company fully controlled by foreign directors, but the actual practical sort of setup might be quite difficult. So who's going to go there and actually set up the bank account? I think from memory the UK doesn't require a resident director, but someone will have to go over there and actually set up the bank accounts and be the signatory on the bank account on behalf of the company. So there are some jurisdictions where you can just do that all remotely. You find a lawyer, or maybe there's an online service, and you can set up your company. You don't need to be based there, and they can take care of all your bank account for you. And then there are some where, like Australia, for example, you need someone on the ground who can be a resident director, and then sort of fair game on everyone else if they can get a director ID. So it's not always a visa issue, but obviously just because you have a company, say for the US example, you might set up in Delaware, maybe there's no residency requirements, but you would still need to go through the immigration pathways to get through.
Thank you very much. Look, that's all we have time for in terms of questions this evening. However, our expert panel will be hanging around, so you're welcome to come and have a chat with them and ask them more questions one-on-one. And please help yourself to some drinks and something to eat and do a bit of networking. We will be in contact with you, as Pat said, by email and by phone, so we'd love to get your feedback on and any ideas you have for future events. Otherwise, thank you so much for coming this evening, and please thank our panel.